Following the first two videos I've done on the Auriol Grey case and the manslaughter conviction and 3-year sentence, doubtless many of you will still have questions over that conviction and over the sentence itself. So in this video I thought I would share with you some of the judge's sentencing remarks so you may better understand it, and as a useful insight into what goes on in a Crown Court when judges passing sentence and the various things that go into that sentence, the various things the judge considers. So stay tuned. Welcome back to the channel. So seldom do members of the public get to hear the sentencing remarks of a judge, unless of course you're sitting in the public gallery, you're a member of the jury, or you're actually involved in the trial itself. So in this video I thought I would go through some of those remarks and I will comment upon various bits of those sentencing remarks as we go through to help you better understand what is in the judge's mind when coming to a sentence. So let's move to those comments now. So the judge begins, "You've been convicted of manslaughter after retrial. You gave no evidence at trial 1 or 2. So just pausing there, it is obviously material whether a defendant gives evidence at a trial. Of course, there is no compulsion upon a defendant to do so, but invariably it will have a negative and adverse effect upon that defendant by giving no evidence at all. Albeit the prosecution still must prove the case against the defendant, it is still the jury that comes to the decision as the finder of fact." The judge goes on, "In broad terms, the issue at trial was whether what took place might have been an accident, self-defense, or unlawful violence. Unlawful violence, of course, being any kind of violence against another person that doesn't amount to any kind of excuse. So violence could be chalked up in some kind of medical setting where it is an incision, a wound, but obviously there it's not unlawful because it's in a medical setting. Self-defense, of course, would have been a full defense if made out, but there is an evidential burden upon the defendant to raise self-defense as a defense in that scenario." The judge goes on, "You were convicted unanimously by the jury." Interesting point to note is that the judge will always, in the first instance, seek a unanimous verdict by the jury. It's not automatically a majority that can come back. The judge will always seek a unanimous verdict in the first instance. The judge goes on, "Most of what took place was captured on camera footage. You were walking on the pavement. You resented the presence of an oncoming cyclist. The footage shows you shouting aggressively and waving your left arm. You do not stop, slow down, or move to one side. You are territorial about the pavement and not worried for your own safety. After careful thought, I concluded these actions are not explained by your disabilities." This is something that many people have quite rightly brought up for discussion, and so this is just to reassure you that the judge has obviously considered all of these aspects, and doubtless there would have been arguments for mitigation during the sentencing process by defence counsel, and these are the judge's remarks in that respect. The judge goes on, "The court heard evidence from a number of witnesses, and I found William Walker to be reliable and thoughtful. He is a cyclist and driver. He said that you and Mrs. Ward appeared to have come to a halt in front of each other, and you made a lateral sweeping movement with your left arm which was directed at Mrs. Ward. He said it either made contact or she recoiled and fell. She fell into the busy ring road where she was killed by a passing car driven by Carla Money. This was, I think, a shared path for cyclists and pedestrians that allowed them to go around the busy ring road. The vital point is, I'm sure you knew cyclists used the path and you were not taken by surprise or in fear for your safety. The path at the point of collision, 2.4 meters wide. I have considered the evidence about eyesight, and the CCTV footage and visual impairment was not a factor in this incident. You and Mrs. Ward both welcomed the safety of the pavement. She because she was an elderly cyclist and you because of your disabilities. Consideration for other road users is the lesson of this tragic case." And just pausing for thought there, that is precisely what I've said in many videos and why I have done so many videos about road safety and respect and courtesy for other road users. The judge's remarks echo all of my thoughts in all of those previous videos. The judge goes on, "We are all road users, whether as motorists, cyclists, or on foot." Again, echoing my previous comments. I've been referred to the sentencing guidelines. I've been referred to the guidelines on unlawful act manslaughter issued by the Sentencing Council, and have heard submissions from both parties. The sentencing guidelines, by the way, are guidelines set by a council on relative offences, which also set out the level of harm, the level of culpability, and a list of mitigating and aggravating factors that might be present. Aggravating, making them worse for the defendant; mitigating, making them slightly less harsh in terms of sentencing. It moves on. In terms of the guidance, looking at these matters in the round, culpability C is made out, but towards the lower end of the scale. A starting point of 4 years seems just, based on my finding that the sweep of your arm was an intentional act, but being reckless as to whether harm would be caused. Just pausing, this answers many questions that I've seen in the comments as to how waving of an arm can amount to a dangerous or unlawful act. And it's precisely this point, that it was reckless as to whether harm would be caused. The judge says, I reject the submission that this is best framed in terms of category D for reasons I've indicated. Aggravating factors. The vulnerability of Mrs. Ward, who was on a bike. The effect on Mrs. Carla Money, insofar as her first statement extends. Her enduring distress is entirely foreseeable. Matters reducing seriousness and personal mitigation. You offered assistance at the scene, but you were turned away by others. But on the other hand, you left before the police arrived and went off to do shopping. You were evasive when the police traced you and told lies in interview. You have no convictions or cautions or reprimands. You are 49 years old. This stands to your credit. Your medical history and significant disabilities would have crushed many, but you have endured all that in a commendable way. Until now, you've demonstrated a positive style, and I've no doubt that over the years you've endured all kinds of difficulties when going around the town centre, which may have made you angry on this occasion. In any event, your prior good character stands to your credit. Is there a mental disorder bearing on these issues? I do not think so. As to learning difficulties, there are none. Much was made in cross-examination of what witnesses referred to as a childlike face. In fact, you went to a mainstream school and denied in interview having any impairment of intellect. That is not decisive, in my view, and I put it to one side. Both experts suggested that the childhood surgery resulted in a degree of cognitive impairment. In my view, these difficulties do not bear on your understanding of what is right and wrong, and what is appropriate or not. I should say that I saw the video, your police interviews, I read the character statements detailing your lifestyle. I've also read the pre-sentence report and medical evidence, and have learned as much about you as I can. Remorse. There has not been a word about remorse from you until the pre-sentence report was prepared. And here there is reference to remorse, which has never been passed on to the Ward family. In this regard, I accept your counsel's explanation that this may be a function of your disabilities and do not hold it against you. Just pausing there, remorse is typically one of the large impacting factors when it comes to sentencing, and here the judge has addressed it. The judge goes on, there's been a delay in getting this case to trial. This is a mitigating factor I must take into account in your favour. I also take into account the particular difficulties occasioned by your disabilities that you will face in prison and when you emerge. Balancing all these considerations, the proper sentence is 3 years imprisonment. Remembering when the starting point, if we go back, the starting point of 4 years seemed just, based on the finding that the sweep of the arm was an intentional act with recklessness as to whether harm would be caused. And obviously that resulted in the sad death of a cyclist. So these are the remarks of the judge, and you can imagine in any case it's not going to be easy reaching an appropriate sentence, balancing so many different pieces of information, so many aggravating and so many mitigating factors together. But this was the analysis that the judge went through, obviously with doubtless reams of paper and reports and arguments on both sides by the prosecution and by defence counsel to bring the judge ultimately to this sentencing conclusion. So I've also want to comment on other pieces that I've seen in the media about the idea that this gives all cyclists free rein, essentially, to ride on the pavement without any consideration at all. Now, obviously, that's not the case, and the judge has made this clear. The judge echoing things that I've said in many other videos, that we all use the roads, we all share the roads and the pathways, whether a driver, a motorcyclist, a pedal cyclist, or a pedestrian. We all share these spaces on the road, and we should all have consideration to each other. The deciding factor in this case is clear, that it was an intentional, angry act which was reckless as to whether harm would be caused. So as I've said in my previous videos and other videos on this very subject, if you take an action which comes out of any kind of anger or any kind of recklessness as to whether harm is going to be caused to somebody else, and some harm does occur, and in worst cases it is a fatal injury, then you will be held accountable, because your actions will have a consequence, both in reality and therefore in law. So I hope you found that a useful exercise to go through those sentence remarks. I hope that it has served to address and to answer some of your questions. And as always, I would really appreciate you liking this video and subscribing to my channel before you leave, so that it helps my channel grow. I enjoy demystifying the law and helping you all to understand it. And from myself, and as I'm sure I can speak for all of you watching, our deepest sympathies for the family involved. And in the meantime, thank you very much for watching. Please do remember to like and subscribe, and I'll see you next time.